The first item on our agenda is the appointment of chairman. Do we have any nominations, please?
Yes, I'd like to nominate Steve Clark.
And seconded? Yeah.
Seconded.
Councillor Clark, thank you.
Thank you, members. Okay. Good morning, everyone. My name is Councillor Steve Clark. I represent Milton Ward in the New Forest. The two other members of the subcommittee are Councillors Dowd and Councillor Sleep. Would you like to introduce yourselves?
Good morning, my name is Philip Dowd and I'm a councillor from Hythe Centre.
Good morning, Councillor John Sleep, and I'm Central Ward Tottenham.
Thank you. In front of me is the legal advisor, Richard Davis, and on my left is the Demographic Services Officer, Andy Rogers. This is a licensing hearing to consider an application for a premises licence in respect of an application for the variation of a premises licence for Sandy Balls Holiday Park Estate, God's Hill. Please note this meeting is being broadcast live on the Council's website and on YouTube. It will remain available for a minimum of 12 months. Please use your microphone when speaking and remember to switch it off. Please switch any mobile service devices to silent. If the fire alarm rings, please leave the room immediately. Use the nearest fire exit. Do not use the lift, and please go to the fire assembly point in the car park. Firstly, I need to check to make sure that I nor any of my colleagues sitting today have a personal or pecuniary interest in this matter, which would preclude us from sitting to determine the application. I do not.
None, Chairman.
No.
No. Thank you. I now need to check whether the parties are present. I'm aware that the following persons have indicated that they will be attending. So John Warsgrove, the Sandy Balls Holiday Park representative, and Rose Brothwood. Thank you. And Councillor Richard Fell, Chairman of God's Hill Parish Council, the objector, and Bev Cornish, the clerk. Claudia Vice, an objector, has not yet arrived. There are no other parties related to this hearing, as well as verbal submissions made today. The points made in writing, which are contained in today's agenda papers, will also be given due consideration. I need to, as we've got one of the objectors not here, I need to ask my colleagues if they believe it's in the public interest for us to proceed. It is now well past the appointed time. Are we all happy that we will proceed?
Yes, Chair.
Just check that's in accordance with the rules, Richard, that we decide we will proceed.
Yes, that's fine.
Yeah, thank you. I now wish to establish the order of events for this hearing. You will have received a copy of the Council's procedure note. In short, this allows the applicant to present their case first. After that, the subcommittee and the objectors will have the opportunity to ask relevant and appropriate questions of the applicant. And I must stress that only questions will be allowed at this point. In other words, no submissions. And just for people who are not used to this type of procedure, I know it's very difficult sometimes to actually ask a specific question rather than talk about the thing. So try to make it a question where possible. After that, the objectors will present their case and the applicant's subcommittee will have the opportunity to ask questions of them. Finally, the applicant and the objectors will sum up their cases and the hearing will close to enable the subcommittee to determine the application in private. The subcommittee will send formal decision notes to all parties within 5 working days. I hope that's clear. Before we start the hearing from the parties, I will pass over to our legal advisor to clarify some matters.
Thank you, Chairman. John Gaunt and Partners Solicitors have submitted an application as agent on behalf of Sandy Balls Holiday Park Estate for a variation of its premises licence under Section 34 of the Licensing Act 2003. In accordance with Section 35 of the Licensing Act, where relevant representations are being made to the licensing authority in response to a premises licence application, the licensing authority must hold a hearing to consider them. However, in regard to those relevant representations, the licensing authority may take such steps as it considers appropriate for the promotion of the licensing objectives. These steps are outlined for the subcommittee and the parties in the report at page 7 of the pack, paragraphs 20 to 22. The report outlines for the parties that representations received by the licensing authorities raise issues relating to noise, particularly at night, and light pollution. I will remind the subcommittee and the parties that the application to be determined today relates to the licensable activities applied for only, and the impact of those licensable activities on the 4 licensing objectives, which are set out in the report at page 6 of the pack at paragraph 17. Thank you, Chairman.
Thank you. Could I now ask the licensing manager to present her report?
Thank you, Chairman. The Licensing Authority has received an application for the variation of a premises licence for Sandy Balls Holiday Park in God's Hill, Fordingbridge. The application seeks to update their plans of the premises to include an extended outdoor area for licensable activities, permission to vary the conditions and limitations around the display of films in this extended outdoor area by increasing these from 2 to 4 showings per week, and increasing the display of films indoors to 10 a.m. to 11 p.m. instead of the current 5 p.m. to 11 p.m. The application is brought before members to determine, as we have received 2 objections to the application, one from a resident and one from the local parish council. Copies of these objections are found in Appendix 5. Objectives have primarily referred to concerns around noise nuisance. A noise management plan has been implemented by the Holiday Village and it is expected to be reviewed regularly. NFDC environmental protection officers are also able to comment on and work with the site directly to ensure the suitability of this plan remains in place. The options now open to the members are the grant of the variation as applied for in full with no further changes, the grant of the variation in part or in full and the addition of further conditions or limitation of the hours of operation and or licensable activities that are being considered by this variation only, or to refuse the variation as applied for in full. Photographs of the premises and the immediate surroundings can be found in Appendix 4 of the report. A copy of the existing premises licence can be found at Appendix 1, and a copy of the proposed variation can be found at Appendix 2. Thank you.
Thank you. Can I now ask the applicants to present their case?
Thank you, Chair. I'll keep my representations to you as brief as possible. I'm just going to set out the several reasons that we submit to you enable you to grant the application, the details of which your licensing officer has just outlined. Before moving on to those reasons, I would just like to remind the committee, although you probably don't need a reminder, but for the benefit of the interested parties, that any decision you make today must be evidence-based. The Section 182 guidance issued by the Secretary of State under the Act, which you must take into account at paragraph 9.43, says the local authority should only make decisions which are evidence-based. And there's a High Court decision which effectively affirms that guidance, the Daniel Thwaites case, where the judge essentially said the court should rely on credible evidence rather than any speculation from interested parties. And also in that case pointed out that insufficient weight had been given to the fact that in that case the police hadn't objected as one of the responsible authorities. Which brings me on to the first reason why I say you can grant this application, which is this: none of the responsible authorities have made a representation against the grant of this application. And again, perhaps for the benefit of the interested parties rather than yourselves, the Section 182 guidance says that a local authority must look to the responsible authorities as experts and look to them for their first source of advice in relation to specific licensing objectives. So in relation to the prevention of crime and disorder, you would look to the police as the experts in relation to that, and for public safety and public nuisance, obviously towards your own environmental health officer. So I say that those expert opinions are credible evidence on which you can base a decision to determine this application, because they have looked at this application objectively. Both we as the applicants and the interested parties clearly have our own purposes to serve in either having the application granted or refused, but the responsible authorities are entirely objective and only look at what the possible impact could be in the application being granted. And as I say, the police and environmental health in particular, out of those responsible authorities, have not objected. So I ask you to attach great weight to that. The second reason I would submit is that the outdoor cinema has operated at the park for the last 9 years. Now, we're aware from the licensing authorities' report that 2 complaints have been made within that 9-year period about the cinema, but those complaints have not been referred to Sandy Bulls. As far as the management of Sandy Bulls are concerned, they're not aware of any complaints having been made about the outdoor cinema. So operating that for 9 years with effectively entirely unsubstantiated complaints, we say that increasing the number of films permitted outdoors and extending the hours for those films showed indoors will have no negative impact on the licensing objectives, because it's been proved to be the case. Again, credible evidence on which you can rely. Aside from the environmental health officer's expert view, which is increasing the number of films to 4 per week as a maximum, would not have any adverse impact on the prevention of public nuisance. What I would say is that in terms of the application where we're asking for it to be increased to a maximum of 4 per week, and also in relation to the hours for the indoor films, and all in relation to the mobile bar at the pool until 10 p.m, because we're here asking for that does not mean that there's going to be 4 films every week and people outside at the pool until 10 p.m. Every day. It is to provide the flexibility for the management to be able to, at peak times in the season, for example, to show the films, and a higher number of films per week. And obviously in relation to the bar at the pool, currently the pool closes at 6 p.m, and for the vast majority of the time, if you grant this license to allow the bar to be there, that's when it would close. But obviously the management would like the flexibility for events, owners' events, etc. through the year to be able to open that bar until later into the evening. And again, police and environmental health say that that's not going to have any negative impact. So the previous trading history of the premises is relevant to this application. The third reason, which ties into that flexibility that I've just outlined to you, is that the Section 182 guidance was fairly recently amended and an additional paragraph added at paragraph 1.18 of that guidance, and it directs licensing authorities to consider the need to promote growth and deliver economic benefit. National government recognises that hospitality has been through quite considerable stressful times over the last few years, particularly following COVID, and now they're directing licensing authorities to make sure that that is a consideration before you. So again, my submission to you would be that this would deliver growth and economic benefit, and I think the interested parties recognise that this is a commercial business, but the overriding safeguard here is that the licensing objectives obviously would take a priority over that economic benefit and growth, and we say there's going to be no negative impact on those. So you can take into account the significant benefit this will have for Away Resorts as an organisation, because there's no fear that it's going to have that or any negative impact. The fourth reason relates to the outside bar, and the situation currently is that people who are staying at the park on holiday would be able to go to the bars within the park and get drinks and take them to the pool in any event. So this is all about creating the right customer experience. And so the company want to have the flexibility to have a bar there, which in my respectful submission would add to the supervision of that pool area, because there'd be a staff member at that bar in addition to the lifeguarding that's taking place. It's not going to increase the numbers of people that stay at the park. None of this application is designed to attract more people to come to the park. It's about customer experience and Away Resorts being able to deliver the best experience for those customers staying at the park. Because obviously, at each of the holiday parks around the country run by various different operators, there is competition to get the holiday makers into their holiday parks to try and maximise the bookings through the holiday seasons. And so providing the customer's experience is all about having that economic viability to make sure the park can continue. So the fact that there wouldn't be any increased numbers at the pool consuming alcohol, we say, is clearly demonstrative that there wouldn't be any negative impact on the licensing objectives. Obviously, the noise, outside noise, would be monitored by both the management team and the supervisor at the bar to make sure that there isn't the likelihood that the nearest local residents would be disturbed from it. The complaints that have been made previously to the park, which are few and far between, and those made to environmental health, actually relate to when they have amplified music outside. That is more of a problem that Away Resorts and the management team there have to control. There aren't any complaints, and management need to deal with the cinema, nor for people drinking outside or making use of this mobile bar, because, as I say, that's just a service facility. It's not an increase in the number of people that will be consuming alcohol at the park. And the final point to make, the Licensing Act was supposed to be a permissive act, is supposed to be a permissive act, to remove regulatory burdens from responsible operators, to allow them to run their businesses as they see fit. And the light touch that you can apply to an application is protected by the ability for anybody at any time to review the premises licence. So the speculation around what the interested parties say will happen if you grant this application, where they have no credible evidence to, in my respectful submission, defeat the application and get you to refuse it today, should that they have that credible evidence in the future, where if you grant 4 films and they suddenly do cause a nuisance, it's incredibly unlikely, but if it did, they can bring the matter straight back to you and say, this was the impact it had. It did have that negative impact. Your environmental health officer may well then take a different view, having substantiated any complaints that have been made, and the licence can be varied and changed by removing them. We say now is not the time to do that. Now is not the time to impose those restrictions. You should be able to trust the operator when they say, by having the additional films, by having the outside bar, there will be no negative impact on the local community, and that is supported by the responsible authorities. We're obviously happy to answer any questions you may have, but I'll leave my representations there. Thank you for listening.
Okay, thank you. I'll go to the objectors now. Do you have any questions?
First of all, I'd just like to ask whether Sandy Balls are complying with the current conditions of their licence, because Rosie has explained to us at many council meetings that there is no general manager handover from one to another. So that's my first question, please.
I'm not sure I understand the question. What do you mean a handover?
Well, when we've asked about handover from general manager to general manager, you're talking about Away Resorts, Sandy Balls being a responsible company, surely they will be a full and comprehensive handover. Because when we've referred to things, there doesn't appear to be any ongoing knowledge passed on.
There's always a handover when the GM changes at the park. The DPS named on the application has been there for the last 4 years. And obviously the designated premises supervisor in relation to anything on the licence is the first point of contact for responsible authorities and for interested parties. So yes, those processes are in place. And in terms of which I assume in reference to history would be the logging of complaints. So those records are kept and maintained by the park. And indeed, I asked Rosie to review the number of complaints that had previously been made, and that confirmed that there have been no complaints made to the park or to the company regarding the outdoor cinema, and that in fact the complaints that have been made directly to the park, and indeed we say those principally to environmental health, relate to amplified music, which is not something which is under consideration today.
Okay, thank you. Second question then is one.
Sorry, Chairman. I just wonder, I think it ought to be noted, the addition to the parties.
Yeah, no, I'm aware that Caroline Weiss has entered. I'm not going to restart the process, but obviously allow you to fully participate in asking your questions, and I'll explain that to you in just a moment.
Okay, next question then, thank you. One of our residents has told the council that they've complained about the noise and asked for it to be turned down in this year alone on 6 occasions: 20th, 25th of July, 3rd, 7th, 8th and 10th of August. Now, I don't know whether that's relating to cinema or just general noise. Have they been recorded in your logs?
Can I ask you to turn on my thoughts?
You're asking about specific dates, which I don't believe are in the representations. Yes, if a complaint has been made to Sandy Balls, it would be recorded. I can't answer the question specifically on those dates, what that complaint related to. All I can say is, as an example, a complaint was made by a local resident this weekend about noise, music noise, and the park said it's not us. So the resident came to the park and confirmed it wasn't actually noise that was coming from the park, it was coming from elsewhere. So a lot of complaints may be made, and as the environmental health officer for the council has been unable to do, those complaints have not been substantiated. Yes, there have been some complaints about amplified noise, amplified music, which the park have proactively dealt with when those complaints are made, and would continue to do so obviously in the future. So if they have amplified, even though that's not relevant today, but if the amplified music outside is causing a problem for residents and they contact the park, there is that engagement to ensure that no nuisance is being caused. And yes, it's logged if a complaint's made.
Okay, thank you.
Can I just come in? I think it might be useful that if our legal advisor explains the rules about amplifiers, we've mentioned amplified music, if we just highlight the laws around amplified music. Richard.
Thank you, Chairman. Whilst I won't read them all out because there is a long list of them, and the entertainment that is allowed, that is regulated regarding live music and live amplified and live recorded music, generally, if there are fewer than 500 persons being part of that entertainment, then there is no license required to be able to do those different, provide those different types of entertainment. I can go into them if you do raise those points specifically, but it's between 8 AM and 11 PM, which requires no approval by the licensing authority.
I just wanted to have that sort of clarified. As is pointed out, amplified music is not part of this application, but noise and amplified sounds clearly are being referred to.
Thank you. In the case of the dates I mentioned there, James Cowper has responded immediately when they've complained, and on occasion he's instructed his team to turn down the music, which helped a little. However, there has also been times when he said that the music can't go any lower, and the particular complainant in this case could still hear it. The noise is not only audible in their garden, but could also be heard inside the house. The resident requested a copy from NFDC licensing of the site's noise management plan. This request was refused, even after the Freedom Information request was submitted. My question here is, if Sandy Balls say they're compliant, why is this plan not publicly available? And Rosie has actually offered us a copy, which we still haven't received.
It's difficult to answer that because we're talking about amplified music again, which is not part of the application. We're dealing with an outdoor cinema, which hasn't had the complaints, and we're dealing with a mobile bar at the pool. There's no requirement for any licensed operator, unless there's specifically in the condition that the noise management plan should be disclosed to anyone other than environmental health. If Rosie has said that she's happy to let you have a copy, then I'm sure after the hearing she will provide that. But there's no obligation to do so. The only obligation is to comply with the conditions on the premises licence and to ensure, obviously there are other statutory provisions regarding noise nuisance, the Environmental Protection Act, that they don't cause a noise nuisance. And as you've said, there is proactive engagement with residents when a complaint's made, and there's an assessment that yes, the impact of that music may be causing a nuisance, they will turn it down. But there are also occasions where complaints made where their music is not causing a nuisance, and on those occasions they will not need to turn it down. The fact that someone makes a complaint does not make that complaint justified.
Mr. Chairman, can I just have a legal clarification? We're talking about amplified music a lot, but amplified cinema, the volume varies dependent on the mood, the scene, the getting the audience's attention. Is there a different definition in licensing for amplified cinema?
I accept amplified sound means the same thing, but you were making reference to specific complaints. There haven't been complaints about the cinema, only amplified music, and amplified music isn't relevant. There haven't been any complaints about the cinema.
The reason I asked for the legal advice just now is there is often a confusion between the different types of sound in locations such as this. So there could well be music, which is amplified, and then there's the sound of the cinema, which is amplified, and that could contain music. But if it's amplified music, then the rules changed from the initial legislation way back. And as was pointed out by the legal advisor, under 500, there is no restriction on amplified music. That doesn't mean to say that no action can be taken. There are environmental health rules on noise, and that comes under a different set of legislation, and that would be dealt with by a different process, and it could impact upon a licence, but first of all, that would have to be an environmental health matter. I'll just check that I've got that right with my legal advisor.
Yes, that's correct.
I know it's complicated, but this is the problem. We don't expect our members of the public to understand all the vagaries of the law, and often with a licensing hearing we get conflicts of legislation, including planning and environmental health, etc., which is very difficult for the average member of the public with no specialist knowledge to understand. It's something we have to sort out. It's one of the reasons we have our legal advisor here, and it is all trying to separate all these issues out. And as the legal advisor pointed out, we have to be evidence-based and be fairly precise on that evidence base.
Thank you for that. another resident has reported that the music coming from the entertainment area, in particular the swimming pool, is louder inside their house than they would have their own radio on, volume-wise. So for hours every day, they listen to Sandy Ball's choice of amplified music, whether they like it or not. When working from home or returning home after a hard day's work, it feels extremely invasive. They have no control over whether or not or what type of music they are subjected to.
Can I ask you to turn that into a question a little bit sharp? I appreciate that difficulty of doing that,
Right.
but you will be able to outline that in just a moment in total.
Okay, so how can Sandy Balls then reassure this resident that any additional hours at the pool won't cause disturbance, nuisance to their and their family's normal life?
Because, as I said to you, the application is for a mobile bar, effectively, a service point to be at the pool. That is not going to increase the numbers of people that are able to drink outside in relation to any events that Sandy Balls put on. So there's not going to be an increase in the numbers of people or the number of events, etc., etc. This is about a bar providing a service. People can get alcohol from the bars and drink it outside in any event. And as I said, the complaints that have been made previously to the park and to environmental health have related to events where live music has been played outside. The environmental health officer has said what we're applying for today is not going to have a negative impact on nuisance at the park. It's difficult in a hearing when we've read the representation and now you throw additional information which wasn't included in those representations, including specific dates or further allegations, to be able to respond to them properly. When we've not been given that opportunity, I don't have all of the logs. All I can say generically is that complaints made to the company, to the management of the park, have related to live music events. There hasn't been a complaint about music playing during the daytime when people are enjoying themselves at the pool, and nor has there been any complaints, as far as I'm aware, to environmental health about that. And that's something which has come to the hearing afresh, effectively, today, so I can't answer it.
Okay, so we're still talking about amplified music here, but obviously you're saying that the only complaints you're aware of are live music complaints. So the shocking karaoke that goes on, that I expect from somewhere like Butlins, is it not professional music? So if you're playing audio from, let's say, Adele, there's no complaints coming in about that, but just somebody trying to, just a live event?
I'm going to allow that question, but I'm going with the caveat that it is still about amplified music. It doesn't matter whether it's professional or otherwise, and that's not what the application is about. There is a different process, but I'll allow that to stand, that question.
Yeah, so previous complaints that the park are aware of are when they've had events and they are playing amplified music, whether that be a live band, whether that be a DJ playing recorded music, which is a DJ playing music is actually live music because it's someone performing, playing recorded music. It's all to do with the playing of amplified music at events, not to do with the cinema, other than 2 complaints in the 9 years made to environmental health which weren't substantiated, which are in the licensing authority's report, and nothing to do with the noise of people just having fun when they're outside at the swimming pool. And that's the application. So we're not touching having live music and amplified music at events. That's nothing to do with this committee today. And previous complaints about amplified music at events, whether it's DJ, live music, etc., etc., you have the protection, as I explained to the committee, of bringing a review of the licence if you can provide evidence that those complaints are substantiated. But that's not relevant to the variation is very minor in its terms, and this committee, with the greatest respect, cannot look beyond what we've applied for, which is the bar at the pool and 2 more cinema viewings per week as a maximum.
Okay, can I confirm then that the licensing application is for amplified music to be played beyond 6 to 10?
I'm going to intervene again here because, as has been pointed out, the licensing application is not for amplified music. It is for an extension of the licensed area, which includes the minibar, and an extension with, for various times and throughout the year for the playing of live film. Any amplified music comes under the rules which we highlighted earlier, which do not need to be regulated if there are less than 500 people. So there is no application here within this hearing which is looking at amplified music per se.
Okay, thank you, Mr. Chair. So basically, we're looking, so there will be music played at the pool in these extended hours, surely?
Unlikely, but there may be background music for people there. There's not going to be an event specifically with amplified music at the pool, although obviously the premises licence does already have regulated entertainment licensed on it, both indoors and outdoors until midnight. So no, this is all about an application to provide a service bar at the pool. And I don't know how many more times I can say it, frankly.
So to clarify, is the music going to stop at 6?
The problem, and I know it's difficult for you, but music is not part of this application. It is the sale of alcohol from a minibar at the poolside, and the music is not under this application.
Okay, thank you. I'll move on to my next question then. So, do Sandy Balls and Away Resorts fully understand the geography and topography of God's Hill as a village? And we're talking about
Yes.
the village. The holiday park is not the village.
Yes, of course they're aware of the interaction, and as you know, are willing to engage and communicate and keep a good relationship with residents, and obviously respond to issues that arise. Likewise, they have an excellent relationship with the responsible authorities, and if environmental health have concerns, which they do not have, then Away Resorts and the management at Sandy Balls would work with them to resolve those issues. But I think you've missed the point there that environmental health, who are the experts, have said this application will have no negative impact on the local community.
I totally disagree with that. I think a lot of people don't report things to environmental health. They report them to Sandy Balls.
You're making a statement
Okay,
now.
sorry, I'll move.
When it comes to your side of events, that I will allow that. But at this point, yeah.
So I was assured by Away Resorts CEO Carl Castledine years ago that his plans were to take Sandy Balls upmarket. Karaoke, amplified music, outdoor cinema seems the exact opposite. We all live in villages in the New Forest.
You're making a statement again. Can you come to the question?
Yeah. Why is this not the case? Why has there been a U-turn in the company's philosophy?
In terms of what direction the company moves in, again, with the greatest respect to the 3 councillors, is not a matter for them, nor is it a matter for anybody else except that company. I don't know what Carl Castledine said all those years ago, and he's no longer at the company. Obviously, what the business need to do is make it sustainable for the long term. Outdoor cinema is very popular with visitors to not only Sandy Balls, but numerous other Away Resorts parks. And there is an expectation now that those holidaymakers who come to Sandy Balls, they go to other away resorts, holiday parks, they're used to facilities being provided, and sometimes the limit of having 2 films a week, those customers can't quite believe that they're not getting the same kind of experience as they would at any other park that's showing outdoor cinema, because I can tell you, I look after all of Sandy Balls Park, and this is the only park in the country which has restrictions on the number of times it can show outdoor cinema. The whole issue here is about whether it's likely to create a public nuisance. You will have your say in a moment about your view on whether it does. We're relying on an expert's opinion, the council's own environmental health officer, and that's the challenge for the committee, to decide on the evidence which has more credibility. The back and forth of these questions about music, which I think we've all agreed now is completely irrelevant. Yes, the amplified sound of the outdoor cinema would be relevant, but there have been no previous complaints about that.
Yes, can the committee understand that this application might be is possibly the application that breaks the camel's back, and that can it be understood that this cannot be seen? Well, it's technically.
You're making a statement at this stage. I need you to ask questions. I know this is difficult.
Is it feasible to understand that this is an application that comes alongside a whole raft of previous applications, large and small, and changes that have led to a deterioration?
You've got the question there.
Yeah.
So I'll move to the answer. Is this going to change anything?
Obviously, businesses have to be dynamic. I've said to you, I represent away resorts throughout the country. We are making changes to their licenses at different parks on a fairly regular basis because things change. Away resorts at Sandy Balls always wanted to show more than 2 films, outdoor films per week. So the application originally, when they asked for outdoor cinema, was without any restriction. Because that went through, and again, I'm going to go into the realms of some legal matters which I hope won't confuse things too much, but we applied for what's called a minor variation to add films. And if you get representations, the licensing authority have to make the decision whether it should be granted or not. A minor variation doesn't come before a committee. The Environmental Health at New Forest at the time said, well, look, if you agree to only showing outdoor films twice a week, the licensing authority can grant you the minor variation, rather than have it reject it, apply for a major variation and end up in a hearing. So Away Resorts, as a conciliatory move, agreed to only having 2 films a week. They always wanted to show more, but they've done that for 9 years. They're coming back to you now to say, look, we have proved that this is not an issue. Why can't we show more films? To be honest, there shouldn't be any restriction. They should be able to show as many films as they want because they prove they don't cause a nuisance. But again, to be conciliatory, they've limited the application to a maximum of 4 times a week. And as I said, that's not going to be 4 times a week, 52 weeks of the year. It will be a peak season. And in relation to the other part of the application, which is the mobile bar at the pool, which again, although we've applied for that to be until 10 o'clock, invariably is only ever going to be used till 6 o'clock, and invariably is only going to be during the summer season, not the whole year round. And that, as I explained to the committee in my representations, but unfortunately you weren't here then, is to do about the customer experience and improving the customer experience, which they are constantly reviewing year on year. So I think in answer to the question, no, this doesn't necessarily mean that they won't review in the future what activities they are providing, and if that needed a change to the licence, we may find ourselves back trying to persuade the committee to allow that licence to take place. But all the committee can take into account today is what we've applied for today, and I've explained the reasons for that change for today.
So can we expect further intensification from the business? More and more and more?
Well, I can only answer that as at today's date, which is no. I mean, this is the application before you. They have a finite number of bookings that they can take in terms of the accommodation they're providing. So as at today's date, the answer is no. But being realistic, I couldn't say in the future whether that view changes. It may. But that's not for the committee to decide on what may happen in the future.
I think, and again, that would come under a different set of legislation. I've got one or two I want to ask, and I'll move to the other councillors. I'm assuming that in accordance with most Licensing Act procedures, you maintain incident logs.
Yes.
Okay, just simple yes on that, and that would include, so anybody putting in any form of complaint, that would be logged in your incident things, which you would be able to check on specific dates.
Yes, we would.
Yeah, okay.
And in relation to that, it would identify who made the complaint, what the complaint was, who dealt with it, and what the outcome was.
Okay, that's fine. That's a pretty standard requirement on all licences. So there are logs that are kept of when phone calls come in, or should be, which will be able to be ascertained if we have the relevant dates. You mentioned the pool currently closes at 6 p.m, which has been highlighted there. I take it that's a commercial decision to close the pool for various reasons, but there's no restriction on you opening the pool for any time.
Correct. I mean, that tends to be the cycle of use by the people that stay at the park.
Peak times, what do you describe as peak times?
Well, that would be the summer holidays. So probably the park is at its fullest, shall we say, between June and the end of August into September.
Okay, that's what I thought the answer would be. And what's the capacity of the park at any one time?
It is approximate, about 1,000.
Taking part in the activities at any one time, less than the 500?
Yes, definitely.
Okay. And your noise system, have you got a dB monitor?
Yes, is the answer to that. And again, the difficulty with noise, and I don't want to get into talking about the expertise of that, but so dB monitors where clients use them themselves are good measures to have in place. They're not sophisticated enough, in my view, to be able to assess properly the entire impact on local residents. That's where your own environmental health officer's opinion is much better than the staff at Sandy Balls, but they manage it as best they can. As I say, in the last 9 years since we've had the cinemas showing, there hasn't been a substantiated complaint that a nuisance has been caused.
Okay, no, I appreciate the difficulties with DB monitors, etc. But you've obviously got it set at a level. What sort of level have you got it set at as an indication?
Obviously, in respect of the entertainment facilities, there is an entertainment manager and they have control of that. But Rosie's trying to give you the best answer she can. She thinks that it's 84 would be a maximum on site, which obviously would be much lower. But I mean, I wouldn't hold her to that.
84 is one of those figures within the rules, as I'm sure you're aware as well.
Yes, but as I said, in relation to dBs, you can have a maximum noise level at 84, which would be acceptable. But for example, if the bass within that 84 and the frequency was higher, it wouldn't increase the 84 dB, but it could potentially cause a nuisance. So I'm not suggesting to you that, oh, they always comply because they've got this monitor that says 84, because I'll be honest, there could be occasions where if they're playing a particular style of music, etc., there is a potential there, but they manage that. And as I say, we're putting forward environmental health view rather than our own.
The point I'm making is just on that. You've got a monitor; it enables you to do it. But the problem with noise is it has different effects in different environments, etc. And it's not an easy thing to manage. And there's a perception element as well. I do appreciate that.
And you know, to be perfectly honest, and the residents may mention it, but even the direction of the wind will have an impact on noise on a particular day. So. Which is why generally licensing committees only impose conditions around dB levels, etc., when they've had the input from their own officer, because that's the expert opinion. We could talk about it all day. But
I'm going to stop that line of questioning now. But it is one of those difficult things, and that's why the environmental health. And at some stage, we probably need to explain to this side the rules in that respect. Just one other point from me, and then I'll move to the other councillors. Within the pack, there is the verderers rules about the area of special importance, the tranquility, etc. Are you aware of that, and are you, as a responsible organisation, anxious to or willing to try to comply with that as far as reasonably practicable?
The bottom line is, yes, they're aware of it, and the bottom line is this park cannot create a public nuisance because there's the Licensing Act which protects it, and there's the Environmental Protection Act which safeguards those aims and objectives to provide a tranquil and quiet area for the residents. And so away resorts work within the law to ensure they're not creating a public nuisance. And if they were, your environmental health officer would be here and he'd be saying, don't do this because it's going to have that negative impact.
Okay, Councillor Dow.
Thank you. You've already given us an outline that you have around about 1,000 people in the park at peak times, and you have under 500 at outside events. How do you measure how many people are present for outside events and things like that?
So the outside events are effectively self-controlling in terms of numbers. So for an outdoor cinema, you're unlikely to get more than 100 or so people, watching the cinema at any one time. There's a huge amount of facilities on Sandy Balls Park, most of which people will partake in at some point during their stay, but it's not a case of everybody on every occasion, whichever event they run, that people are turning up. So they're not getting anywhere near the levels of 500 people when they're organising entertainment for them. So for example, the playing of bingo, it's not everybody's cup of tea, but they will get a certain number in for the bingo. It's not going to be anywhere near 500. The cinema, the swimming pool, will be popular with people, but you're not going to get, anything like hundreds of people there all at the same time. So in that sense, it's kind of self-controlled. And then they're not counting people in and out of the bars or the cinema, etc., because they're not reaching unsafe capacities.
Right. So just to clarify, from your own perspective, in terms of managing the park, there are really no occasions when you're worried from a capacity point of view. It might be stretching it, but if it is, you would have procedures in place to manage that.
No, that's exactly right. So each part of the entertainment that is provided, obviously there's a bank of experience, not just from Sandy Balls putting the entertainment on year for their holiday makers, but all the other parks. And obviously as general manager and the entertainment manager, with their reviews of events that they'll put on, they'll need to ensure there's an appropriate number of staff to be able to provide the customers with the experience they want, but also to ensure the health and safety on site is also properly risk assessed. So whatever it is they're doing on the park, whatever activity, they will have assessed what's the anticipated number of people that will be coming to this event, what staff will we be needing there to supervise that event. I hope that answered.
Thank you.
All my questions have been answered. Thank you, Chairman.
Okay, thank you. We'll now move to the objectors. I'll go first of all to Councillor Richard Fell.
Good morning and thank you for the opportunity to speak on behalf of the Parish Council and God's Hill community. The Council shares the concerns raised by many residents as set out in our letter to the Licensing Authority and believes the proposed variation is likely to have significant detrimental impact on their enjoyment and their homes and the surrounding forest for a substantial part of the year. Impact on the tranquility of local residents. God's Hill is located within the New Forest National Park, as I'm sure many of you are aware, and is shown within a highly tranquil area in the New Forest Park Authority's tranquility mapping. For residents who have chosen to live in our parish, the expectation of living in a peaceful and tranquil environment is an important part of their quality of life. Persistent noise associated with Sandy Balls Holiday Centre has undermined that expectation, with residents reporting considerable stress and frustration over many years, and one resident feeling compelled to recently to make 6 noise complaints to Sandy Balls in less than a single month. Now, they should be recorded. When people have gone to environmental health, they haven't come back for over a month. So there's no opportunity for them to come out with a decibel meter to anybody's house to measure readings. The Council therefore questions whether the existing licence condition is operating effectively when the licence states. The licence holder will assess the likelihood of any impact of any noise from the premises on neighbours from time to time and implement such other measures as considered necessary or as agreed in writing with the Environmental Health Officer. The licence holder will continue to liaise with neighbours when this is considered appropriate. The Council asks the Licensing Committee to consider whether adequate and effective assessment of noise impacts is currently taking place, particularly in the circumstances where residents continue to experience disturbance and feel the need to make repeated complaints. The cumulative effect of the proposed activities. The Council understands that the outdoor swimming pool currently closes at 6 p.m. The granting of the variation will permit alcohol on sales in the indoor swimming pool area until 2200 daily, and possibly or possibly not music. It has not been made clear whether the pool itself would remain open throughout those hours. However, the Council is concerned that permitting alcohol sales in this outdoor area until 2200 could lead to increased outdoor congregation, voices, activity and lighting later into the evening, particularly affecting residents who live within a short distance of the pool area, both outside and inside the site. This concern is particularly relevant during the summer months, when residents are more likely to have their windows open or be sitting in their gardens. The Council therefore asks the Committee to consider what measures or conditions would be necessary to ensure that the extended availability of alcohol in this area does not give rise to public nuisance. The second part of the variation would increase the permitted number of outdoor films to up to 4 per week, with performances potentially continuing until 2300. Sandy Balls is already permitted to hold 25 outdoor events with amplified music between March and October. So if the existing entitlement to amplify outdoor events remains, alongside the proposed evening activities at the swimming pool plus proposed film permissions, the combined permissions could result in a substantial cumulative number of outdoor evening activities over the 8-month period. The council has previously suggested headphone use for silent discos, outdoor films, karaoke, and possibly even bingo, now we know that goes on, in order to minimise their disturbance to neighbours. The council urges this committee not to consider each activity in isolation. The relevant question is the cumulative impact which the existing and proposed permissions could have on residents, particularly when events may occur on consecutive evenings or overlap with other permitted activities. This is especially important when many residents work full-time or require their homes to provide a reasonable opportunity for rest and quiet during the evening. Noise after advertised finishing time. The stated finishing time for the outdoor films is 2300, but this does not necessarily mean that the disturbance ends at 2300. Visitors leaving an outdoor film have to return to their accommodation, potentially in groups. We're saying under 500 people attend these things, and may continue socialising and participating in other holiday activities afterwards. The licensing committee is therefore asked to consider not simply the proposed finishing time, but the likely real impact on neighbouring residents during the period immediately afterwards. Light pollution and protected environment, something we feel strongly about. The proposed increase in outdoor film activity raises concerns regarding light pollution. God's Hill is a rural community within a highly tranquil area of the national park. Sandy Balls is also located within the Western Escarpment Conservation Area. The rural character of this location, together with the protection of tranquility and avoidance of unnecessary artificial light at night, are important considerations when assessing the potential impact on neighbouring residents. Outdoor film screenings necessarily involve lighting, illuminated equipment, audiences and associated activity, and health and safety for the lighting as well. Increasing the number of such events could therefore have a cumulative effect, not only on the residents, but on wildlife and the character of the protected environment. The Council asks this committee to give appropriate consideration to these matters when assessing whether the proposed variation would undermine the licensing objective of preventing public nuisance. Relationship with the local community. The Parish Council recognises that away resort Sandy Balls owners have a business to operate. It has worked hard over the past 10 years, despite the high and constant turnover of general managers, to maintain a constructive relationship with both the directors and the general managers. However, the Council considers that this relation should not prevent it from raising serious concerns when proposed changes have the potential to affect the quality of life of local residents in a significant way. It is the Council's view that this application appears to seek to increase the attractiveness and range of the Sandy Balls holiday offering at the expense of the tranquility currently anticipated and enjoyed by neighbouring residents and visitors to the area. It asks the committee to recognise that Sandy Balls Holiday Centre is not an isolated commercial leisure site in an urban environment, but situated within a rural village in a conservation area of the New Forest National Park, identified as having a high degree of tranquility. Topography and potential for public nuisance. The Council considers that the physical characteristics of the site on a ridge to be particularly significant. The Sandy Balls site sits on a ridge within God's Hill, while the established village extends across two valleys either side. This creates, in effect, an amphitheatre, extending around the site and facilities that facilitates the transmission of amplified sound and sound over a wide area. The number of objections and representations received by God's Hill Parish Council from residents demonstrates that concerns about noise are not isolated and confined to a single property. They indicate a wider and persistent issue affecting residents across God's Hill, whether these are reported to environmental health or not. The Council asked the committee to assess the likely effects of the proposed variation, taking account of the characteristics of the local location, to consider whether the measures and conditions proposed by the applicant would be sufficient to prevent public nuisance outside the site, whilst at the same time protecting public safety within the site. Nature of the holiday destination. The Parish Council maintains the view expressed when responding to the previous premises licence variation application in 2020. The majority of visitors staying at Sandy Balls, as well as those staying at local bed and breakfast and camping establishments in God's Hill, choose to holiday in the area because of its special qualities, of the New Forest National Park, its tranquility, landscape, wildlife and rural character. These should be the site's unique selling point, not bingo. They do not necessarily come to the area seeking the type of intensive outdoor entertainment which might be expected at other sites within Away Resorts' portfolio of parks or at other large commercial holiday resorts. We therefore question whether increasing the frequency of outdoor films and other evening entertainment is compatible with the particular character and setting of this holiday centre and its surrounding community. Conclusion. To conclude, the Parish Council recognises Sandy Ball's commercial interests but believe that these must be balanced against the legitimate interests of permanent residents and the protection of the rural and protected environment in which the business operates. The proposed variation would increase the frequency and duration of evening activities, and when considered alongside Sandy Ball's existing permissions, could substantially increase the cumulative level of noise, activity and light affecting neighbouring residents and the surrounding environment. The Council is particularly concerned about the existing and persistent reports of noise disturbance, the ability of sound to travel beyond the site because of its elevated position and surrounding topography, the cumulative effect of existing and proposed outdoor events, the potential for disturbance to continue after the stated 2300 finishing time, the proximity of some on-site permanent residents to the outdoor film area, the potential impact of increased lighting on dark skies, wildlife and the protected environment, and whether the existing and proposed conditions are sufficient to prevent public nuisance. For these reasons, God's Hill Parish Council respectfully asks the Licensing Committee to refuse the proposed variation, or, if it is minded to grant any part of the application, to impose robust and enforceable conditions which properly protect neighbouring residents and the tranquility and environmental character of God's Hill and the Western Escarpment Conservation Area and the surrounding national park. The Council hopes that this committee will give full weight to the cumulative impact of the proposed activities and the particular sensitivity of this location when determining the application. Thank you.
Thank you, Councillor Field. I need to point out to you that I've allowed that full statement to be made at the hearing. We will only be able to take account of those points which are specific to the application and evidence-based. So you have had the opportunity to read the whole statement. Caroline Weiss, do you wish to?
I would like to include, if I may, a statement from a neighbor who did reply to the licensing committee within the time frame, but the email possibly didn't register. She did not.
I've got to stop you there. Has that evidence been sent to us before, prior to this today?
Yes. Yes.
We've got it.
27th of the 7th, 2026 at 21:46 from somebody called Lisa Grabsch.
I'm sorry, what's the name of the neighbour, please? Who has written it?
Lisa Grabsch.
Lisa Grausch.
Grabsch. G-R-A-B-S-C-H. She suspects that her email didn't sort of...
If you can just pause for a moment, I'm going to go to the licensing officer. Have we had a representation from that person?
Could you please?
Apologies, bear with me. During consultation, 2 representations only were received, and those are being represented here. We weren't made aware at a second time at any point before or after that consultation period that further representations had been made. So I don't know if there was a spelling error or whether it bounced, but I don't have a record of any further.
Sorry, can I confirm the email address it was sent to was licensing@nfdc.gov.uk, 27th of July 2026 at 21:46.
Can we check the spelling of licensing?
LICENSING.
I don't know why that's not
the
come
email
to
was-
us. Sorry, can you repeat the email address again?
Yeah.
Thank you. I can continue looking, but as far as we know, we haven't received that representation. Our apologies.
I'm going to go to my legal advisor.
Thank you, Chairman. This may just short-circuit the whole thing. If we can sort it out, regardless of the fact whether it was sent in or not, it hasn't been presented as part of the hearing, and the applicant hasn't seen it as far as we're aware. So under the licensing hearing regulations, number 18, it says, in considering any representations or notice made by a party, the authority may take into account documentary or other information produced by a party in support of their application, representations or notice, either before the hearing or with the consent of all other parties at the hearing. So I think, first of all, to get round it, or at least to address it as we should do, it needs to be asked of the applicant whether they would consent to it being heard.
We don't consent to it being heard. It's not a valid representation. It wasn't made, and the resident in any event can raise any points within it in support of her own written representation. It's not as if I haven't seen it. I don't know what's in it, but I'm pretty sure it's going to say the same thing that the parish council said and the same thing that this interested party is going to say. So it's not going to add any weight, even if I did consent to it, but I can't consent to that being admitted.
Okay, thank you. Ms. Vice, we can't allow you to read the email, but you are allowed to raise any points you wish to on your own behalf.
Yes, good morning, committee. I share the entrance to my property with the Sandy Balls Holiday Centre entrance and have known the site since 1999. For context, my husband's family have lived in that location since 1976, so I live very, very close to the only entrance, and I'm pretty aware of the goings on. Setting the scene, there have been dramatic changes to my living surroundings since the acquisition of Sandy Balls by Away Resorts in January 2017. This has resulted in a huge increase of visitor numbers to Sandy Balls and the resulting business intensification of the Plateau site, where 2 restaurants, shop, gambling arcade, outdoor gathering place with a screen and stage setting for live entertainment, indoor and outdoor swimming pool, gym, spa, etc. are situated. The pressure of people and ties to these facilities has become immense. The most disturbing aspect is the deployment of many forms of amplified entertainment throughout the Plateau site, often at the same time and physically close to each other. I have witnessed 3 to 4 different noise sources flooding the space, which could be music from the restaurant, the bar, various outdoor sources like the screen, all playing at the same time and even overlapping with each other. In a very recent observation, I saw 2 employees standing in front of the restaurant, called Aubrey's, playing loud amplified music from a portable device, trying to attract the attention of guests, offering rides for children in miniature vehicles. It's very easy to deploy loudspeakers at will. I'm not sure whether that's part of any license agreement. There has also been a significant change to the area next to the house called the farmhouse, which used to be a very tranquil area used by the residents of the farmhouse. And this area has been turned into a sports/games area with Nerf wars, laser tag, gel blasters, archery, etc. These are mostly noisy, competitive, high-energy games accompanied by shouting, that's instructors and players, and on occasions amplified music, unless that stems from the outdoor swimming pool next door, all carried out in this privately quiet residential area and all uncomfortably close to my property. I am not certain how this was achieved and how this can be allowed. Very worrying, Rosie stated in the July God's Hill Parish Council meeting that the outdoor entertainment makes up a considerable element of the company's offering. The central area has become the epicenter of that. There is now often a hum, I can only describe it as a hum of noise audible from this area, a kind of noise dome, a general hubbub, potentially at all times of the year during the day and in the evening. I would also like to mention that in 2021, I did involve New Forest District Council Environmental Health about noise pollution from petrol-powered leaf blowers immediately next to my property and surroundings. Sandy Balls was served a noise abatement order, which subsequently was turned into a permanent exclusion zone for petrol-powered leaf blowers near my property, following a intervention by Sandy Balls, by Away Resorts. I would like to sort of also describe just the interactions with Sandy Balls staff. I am speaking as a person who has been very frustrated over a very, very long time. There is a constant changeover of staff on all levels, including the general manager. As I said to Rosie at the parish council meeting, she might be gone in 5 minutes. There is, in my view, no consistency of approach and not a lot of sort of willingness to engage constructively with people living in God's Hill. There appears to be no accountability. Live events, stroke screen, stroke general amplified music. When I have tried to speak with staff, the legal limit, they're very polite, yet with glazed over eyes. The legal limit of 80 decibels for events like this is always quoted at me as the maximum level of noise allowed. We have now heard it might be 84. All staff, junior and senior I've spoken to, will quote that. So conclusion, it's not too loud. Now I've got here a document from the Hearing Health Foundation. If it sounds too loud, it's too loud. It sounds too loud in my environs. And the Hearing Health Foundation states that sounds at or below 70 decibel are safe. Sounds above 70 decibels are harmful. So we're talking here about 84 decibels on a regular basis.
I hesitate to interrupt because I really don't like to, but this is new information that wasn't contained in the representation. It's claiming to be expert evidence, which I haven't seen, and the information that's being provided, in my view, isn't right anyway.
I was going to deal with that at the end. I'm always keen within these hearings, because of the difficulties that objectors often have of understanding the legislation, to allow them to express their views, and then I will point out that the committee will only be able to take weight of the evidence pertaining to the application. It's always very difficult for the objectors.
Original representations, you can't add in new information. That is new information.
We will exclude that from the...
Right. Yes, so noise over 80 decibel is considered as damaging to health. This approach, the decibel meter set the way it is, does not consider how disturbing noise under 80 decibel can be and how damaging to health. And I can say with certainty that my mental and physical health have certainly suffered by constant stress over 9 years. It also, there's no consideration for the type or drift of noise or frequency of events. And of course, the old mantra deployed by the company is, yes, there will be drift from wind occasionally. We've heard it today. I can also safely say that nobody from Sandy Bulls have ever offered to come to my property to sort of experience the noise perpetrated by them directly, see it from my side.
Ms. Vice, I am going to ask you now to come to a conclusion.
Blah blah blah. Yes, there is sort of, it's what people want. And also an interesting fact, when amplified noise is played, and that's relevant to this application, people's voices invariably become louder. Screaming children spring to mind. Also the question, is children's health being damaged with the hearing, the findings about the hearing? Well, I mean, there's also no willingness to believe village residents. It's not too loud, which Rosie, you said at the recent parish council meeting, and it clearly is, because otherwise we wouldn't have this hearing. Yes, and also, I mean, over years, I have, and it may exclude current employees, over the years, when complaining to Sandy Bulls, the noise may be turned down on this occasion, but invariably gets turned up again soon after and is back up at the next time. And that also serves to not feeling there's no point complaining to Sandy Bulls. This is the thing.
Okay, I think you've explained the situation to us. I'm going to repeat that this committee can only take account of the circumstances of this application. I like to be give as much leeway as possible to objectors, members of the public in these cases, because it's hard for them to understand the full legislation. And obviously there's points that contain a lot of emotion that people want to express. But when it comes to our deliberations, there will be many parts of what you've said to us, which we will, by law, be excluding from our deliberations. We can only take into account the evidence that relates to the application in front of us, which is to the mobile bar and the extension of the licensed area, and to the films. All the other issues that have been raised to this point come under different rules and different legislation, which may need and could be dealt with outside of this meeting and this type of legislation. So I'm going to move on, having said that, but I need to make that clear as we go through the meeting. There's only so much that we can take into account under the licensing legislation. If I can. This is where it gets confusing again for the objectors here. Under the rules and procedures, you now have the opportunity to sum up. So I'm going to say, Councillor Fell, have you anything? Oh, sorry, I've forgotten the. It should be opportunity for the councillors. Councillor Dowd, have you any questions?
I have no questions, thank you.
Councillor Sleep.
Yes, Chairman, just to the objectors as it stands, we've got evidence presented in front of us historically with environmental officers, and we obviously are looking at the swimming pool situation, mobile bar, and extending cinema time. But do you understand, are you all in understanding now that the amplified music and everything else that we've talked about, which necessarily we didn't need to, but it's all agreed by the. You've got an amplified music situation there that's tamper-proof, noise limitation equipment, compressor equipment agreed with the environmental health officer of NFDC and maintained at the existing level, at a level subsequently agreed with the environmental health officer. All I'm trying to say is, do you realise that your considerations at the moment, because of noise and concerns on that, and the environmental health officer is the direction that you should be looking in for that situation?
I think we do understand that. But I've never had an environmental health officer visit my house with any decibel equipment. I don't think anybody in the village has. So this is we put a complaint into Sandy Balls or to Environmental Health. If you're lucky, if you receive a response within a month, and that's too late to come out and measure anything.
They are going to pause that. There are matters here being raised which deal with other legislation, and which I think we would need to deal with outside of the meeting, and perhaps the parish council needs to liaise with the district council as to procedures and systems that can be put in place to raise noise complaints. That's not just specifically against Sandy Balls. That's how that would apply generally to noise complaints. So there are other issues which are causing a confusion of legislation here, but that can be dealt with outside of the meeting. And I think the Environmental Health Officer, I'm sure, will be willing to work with the parish in terms of other legislation. Do anything else to add in terms of? No, I think you've all expressed your views very well.
I think we've expressed the point. I've been lucky enough to live in 2 national parks, and it's quite frustrating that the cumulative effect of these applications cannot be retrospectively brought up. So I fully understand you're dealing with what's been applied for today, but the piecemeal addition of all these things is really destructive to people's lives, and I don't think. It's frustrating that licensing cannot do anything. We're only dealing with this. We can't go back to other things and say, well, they already can do this, that, and this, and now they're asking for more. So that aspect is really frustrating. The fact that you're reliant upon the applicant should record complaints. I mean, it's not in their interest to record complaints.
Just to say that,
I suppose, thank you.
There was a question that I put about incident logs.
Yeah.
It is a requirement of the licence for them to record incidents in a proper way, and that's laid out in the terms of their licence. If you say that they're not recording them, I would require evidence of that. And dates where you say they haven't been recorded, and then the licensing team could actually look at those incidents to make sure they're all properly recorded. It is not something I can accept when you say they're not recording them without the evidence.
I'm not saying they're not. I'm suggesting that it's not in their interest too.
Can I make another comment on the?
I'll allow you one more comment.
Yeah, thank you. It's also what is particularly perturbing and frustrating for me, and I think also the lots of other people in the village, that we are the injured parties in this, and yet the onus is always on us to having to to make having to record and engage, which is hugely time consuming. And which is partly the reason why this hasn't happened. It's this sort of feeling of dejection and always having to prove.
Okay, I think we're repeating ourselves here, and I'm trying to stick to the procedure, but it's actually becoming a little challenging to stay within the procedure at the moment. So just from the applicant's point of view, have you any further points you wish to make?
Just briefly, in summing up, which is just to cover some of the points that the interested parties made. The first one is just to make clear what the application is about, because the parish councillor alluded to the lateness of the hour, 2300, but people are going to be leaving after the cinemas after 11 o'clock, and it will go on later. The licence already permits the showing of films until 11 p.m, both indoors and outdoors. So it's not the extension of hours. The extension of hours is actually during the day. So at the moment, we're not allowed to show them before 5 o'clock in the afternoon. So we've asked to bring that forward to 10 o'clock in the morning, effectively for the children's, be able to show a children's film. It's about the increase of the number. And where there's been some criticism effectively of the councillors in what you can actually determine in saying, well, you can't look at the cumulative effect. That wasn't what I was saying. It's not a question of whether you can look at the cumulative effect, because you can. So when you get an application before you, and I said, whether there's applications in years to come, who knows? It could happen. You are entitled to look at the cumulative effect of adding in more activities and the hours of the activities where it has a negative impact on the licensing objectives. And that's our presentation. We're saying to you, it doesn't have a negative impact on the licensing objectives. We manage it well. We've been doing the cinemas for 9 years without any issues whatsoever. Your own environmental health officer, despite the criticism from the interested parties, will have assessed this objectively and properly and is the expert on public nuisance, not reports off the internet. They've got their own experience, their own expertise, and the government tell you you've got to attach weight to the expert responsible authorities. So I'm asking you, your decision has to be evidence-based. You've got the evidence before you. Your expert environmental health officer, in his opinion, says that by allowing 2 more films per week and by having the mobile bar to service customers is not going to have any negative impact on the local people, and the management and licence holders of Way Resorts will ensure that it doesn't, because otherwise if they change in the future to look at any other activity or come back for you for a change for a licence, if they've caused a problem, as in this case, there would be credible evidence before you to show they had that negative impact, but there isn't that evidence. And for the interested parties to criticise the fact that they're required to bring you some evidence, I'm afraid is a little disrespectful both to this committee and also to my client. I ask you to grant the application as we've applied for, because clearly it's not going to have a negative impact. Thank you, councillors.
Okay, thank you. Just on those points, we will retire very shortly to consider the evidence and the specific facts of this case, irrespective of the outcome, and also it would apply to the current licence anyway. Any person who believes that they have evidence that the terms and conditions of a licence are being breached, and that would include some of the issues that we've talked about today, can at any time contact the licensing department and request a review of the licence, and that's a procedure. So should this licence, and I'm not by saying should, we haven't yet reached that decision, should this licence be granted in its terms, and should there be breaches of, or perceived breaches of that licence, then a review can be requested, and that could be brought back to a committee here again to consider the facts of that potential breach. It's one of the things we always like to point out, that the fact that a licence goes into place because at that stage there isn't evidence. If evidence comes forward, which is sustainable evidence, then a review can be requested. And I think the issue is that perhaps the licensing team and the environmental health team need to work with the parish council so that they fully understand the differences in different legislation, so that we actually remove the confusion, and that's not showing any prejudice to either side. It's to enable that we are fair to all parties to do that. And at these hearings, we're always very keen to ensure that we allow as much fairness to take place and views to be expressed on both sides. And sometimes it's difficult for parish councils, members of the public, to understand the fine distinctions between the different legislation. And those fine distinctions are why we have a legal advisor with us as well, and the licensing team. So we are going to declare the hearing closed, I hope.
Chairman, I know that the applicants were signed up.
I thought, yes, they did. Yeah.
Right.
Yeah, I did get that bit right.
Okay, just checking.
So I'm going to close the hearing now. Subcommittee will retire to make their decision in private and give formal notice of their decision to the parties within 5 working days.